Good morning, everyone. Why don't we go ahead and get started? This is a Governor's Water Policy Rural Groundwater Committee. This is the third meeting of the Rural Groundwater Committee, and thank you for everyone for attending. My name is Bruce Howland, and I'm the advisor to the director here at the Department of Water Resources. Also here at the table with me is the director, Tom Bashotsky, council coordinator, Trent Blomberg, and chief legal counsel, Nicole Klobus. Next slide, please. Go over some of the administrative meeting logistics. This meeting is being broadcast via webinar and is being recorded. The meeting recording materials will be posted to the council's webpage. Only members of the committee will be able to unmute themselves to participate in the meeting. Please remember to identify yourself when speaking. And if there are any technical issues, please call the DWR help desk at 602-771-8444 or email tickets@azwater.gov. Before we begin with the welcoming and the meeting, as we have at each meeting, why don't we go ahead and do a roll call? So I'll ask Trent to go ahead and do that.
Good morning, everyone. As normal, just turn on your mic and let us know you're here, or let us know if you're an alternate. Patrick Adams, Paul Brierly, Maria Dadgar,
Jay Tomkis here as alternate for Maria Dadgar.
Ron Doba,
Here.
Sandy Favorites,
I am here.
Jamie Kelly,
Present.
Senator Sina Kerr,
Grant Hanna here as an alternate for Senator Kerr.
Chris Kuzdas,
Here.
Sharon Megdal,
I'm here on WebEx.
Haley Paul,
Here.
Karen Peters,
Here.
Sarah Porter,
Here, attending remotely.
Stephanie Smallhouse,
Here.
Abe Springer, Craig Sullivan,
Here.
Tom Torres,
Here.
Representative Stacy Travers,
Here.
Chris Udall,
Here.
and Chairman Robert Miguel.
Katasha Nakai, an alternate for Chairman McGill, who's on his way.
Thank you.
Thank you, Trent. If we could go to the meeting agenda slide. Here's today's meeting agenda. We put some timeline on each of these agenda items, and I'm going to ask Trent to make sure that he keeps us on time. As we have at every meeting, we will go over the meeting focus and objectives. We've very much narrowed down and focused today's agenda to discuss the homework assignment that you all had, initiation and creation, regarding the components of the proposed rural management framework. We're going to discuss more in the initiation and creation, council membership, and if we get through that, and if time allows, we'll begin discussing some of the council duties. And then, of course, as we have at each meeting, upcoming meetings, any next steps, and then adjournment by noon today. Next slide. Next slide. This is nothing new, but it's just a reminder on the focus of today's meeting and the objectives of the committee. A couple of factual situation and what's the actual rural groundwater situation in these rural areas. Outside the active management areas and INAs, there is limited regulatory framework for managing groundwater. There are no requirements for metering and reporting groundwater use outside these AMAs and INAs. Some groundwater basins are experiencing significant growth in groundwater use. Many communities are facing aquifer depletion with limited access to renewable water supplies and really no tools to manage the groundwater declines. And there are increasing calls for a framework that will assist rural communities to manage their groundwater resources. Committee goal and objectives that have been outlined by the governor. By December 2023, we need to develop policy, legislative, or other actionable recommendations for the governor that provide a groundwater management framework that assists these rural communities to manage local groundwater resources, protect water users, and sustainably manage aquifers. These recommendations will assist the rural communities outside the AMAs and the INAs in managing local groundwater resources and mitigating further aquifer depletion. And these recommendations should be broad enough to apply to any groundwater basins management needs and customizable to be tailored to a basin's unique characteristics. What I'd like to do after these goals and objectives, what I'd like to do is turn to Tom, and Tom has a few remarks in regards to the goal and objectives.
Thanks, Bruce. So I wanted to add a couple of comments here. I think we've had some great discussions to date. I think we're making progress. Time is definitely short. December's coming pretty quickly. But I wanted to make some comments that hopefully will spur additional robust discussion and help us to focus on the outcomes that we need. So again, the governor is committed to helping rural communities manage their water supplies and protect their aquifers, and this is a priority for the governor. The governor charged the committee with developing a groundwater management framework for rural Arizona as an opportunity for a new path forward. In the absence of a new alternative approach, the governor may elect to pursue an administrative approach, which might include the consideration of new AMAs or INAs. And we need to take action to help protect and manage rural Arizona groundwater basins. And the committee has a real opportunity to come together and make it possible to achieve this, and the status quo is not an option. And I'll...
Thank you, Tom. I appreciate that. I appreciate that background and reminder to everyone. Next slide, please. Our meeting objectives today. If you recall, we began starting discussions on what this framework might look like. And as the Department of Water Resources shared with you some of DWR's thoughts on the framework on a broader scale on almost all components associated with what this framework might look like. As we began those discussions, it became apparent, though, that we needed to go into more detail within each of those elements. So we asked each of you to review the initiation and creation and council membership and provide us comments on the initiation, creation, and council membership. Some comments have been made. We made hard copies of those comments, so each of you should have those comments in front of you. For those of you that did make comments on the committee, please be sure that either we address your comments, or if we haven't addressed your comments, please speak up so that we ensure that we do address the comments that you have made, because I want to make sure that everyone's comments are addressed as we go through this, as we go through the meeting today. And then if we have some time, we'll delve into the council duties. Next slide, please. Discuss components of the proposed rural management framework. Next slide. And this is just a reminder that we're here to draft and recommend a new framework for rural groundwater management. We're going to use the term rural groundwater management area. Now, as you all know, that this initial proposal was built on the local groundwater stewardship area, LGSA legislation. I don't want the committee members to be confused that this is an LGSA per se. We saw the LGSA as an opportunity to build upon because of past input. There's been a lot of input and discussion on the LGSA and the components of the LGSA. It does provide an alternative flexible approach to an AMA or an INA, and that's one of the primary objectives that we're working on today, as another approach, a flexible approach, versus creating an AMA or an INA. And as the director mentioned, that is always an option. Accommodates local situational issues and unique characteristics of each basin, which is important. Local water user oversight. And we haven't deviated from that. It's very, very important that local water users are actively involved in this rural groundwater management planning and as part of this area. ADWR management approval and support is critical as we move forward and partnering together with the local users. And then a focus on priority basins. You've seen, I believe 3 times, a presentation on the data that we have regarding basin conditions when it comes to overpumping. And I think it was very obvious on what priority basins exist and where those basins are located. And essentially, those are basins where the overpumping is occurring today. There's declines in aquifer levels, and there are physical signs of distress. There's wells going dry, or there's evidence of subsidence. Next slide, please. So today, again, our focus on the Rural Groundwater Management Framework and the components are on initiation and creation of the groundwater management area and council membership. Just like to remind folks that there are other areas that we're going to have to touch upon, and we plan to touch upon those areas in future meetings. Council duties, area goals, area plan, sunset and review, and additional concepts. But I'm hoping today that we come to some level of consensus on initiation and creation and council membership. And it may be higher level concepts that we can all agree on, but that's our objective today, is to come to some level of consensus on what initiation and creation looks like and what we can agree upon and council membership. I went through quite a bit there. Any questions before we just dive in? Yes, Ron.
We're not going to talk about funding resources for this tool, are we? I don't see that anywhere on there.
Not
So
at this
that's
point, but that will be at a later date.
Eventually?
Yes.
Okay.
And please make a note of that so that we do touch upon that. So I think that could be one of your comments. Thank you for that. Next slide, please. So the focus is on initiation and creation. Next slide. And you all have seen this slide several times. But when it comes to initiation and creation, part of the department's suggestion is that ADWR has the authority to initiate and create potentially a rural groundwater management area. So if I could just read this slide, and then what I'd like to do is reach out to those that have made comments on this slide and some of the suggestions that others have made. The director may designate an area that is not included with an AMA as a rural groundwater management area. I guess I would ask everyone also to think in terms of, we put quotations around that because we can call this whatever we might want to call it, and if we come up with a different terminology for what this might be called, fine. But I just put the quotations around that because that's open to discussion. If the director determines that one or more of the following conditions exist in the proposed area, the use of groundwater exceeds the estimated recharge rate, there are physical indications of overpumping of water that are documented or reliably observed over time. Physical indications may include declining water levels in existing wells or land subsidence. We removed, which was from the original LGSA legislation, the surface water piece. And then groundwater is the only or primary drinking water supply in the area, and additional action and cooperation are needed to assist in meeting the water supply needs for the water users and communities within or withdrawing water from the proposed area. Some of our committee comments, I know Ron, you submitted some comments where maybe we should consider surface water in springs. Haley and Paul, you submitted some comments, consider keeping surface water language, so that's the discussion that we're going to have here today. Senator Kerr, all criteria are too broad and may conflict with statute, so we're going to have some conversation on that, and I'm kind of summarizing the comments. So, and then Jamie Kelly, you had agreement with the proposed process. So what I'd like to do is open it up now to committee members for discussion on the AWR initiation and criteria. Grant.
Thank you. Grant Hanna with the Arizona State Senate. Before we dive into our feedback on the specific initiation criteria, the senator believes a discussion is warranted about the underlying premise that seems to be driving this discussion. It's been said in this committee meeting, as well as in these most recent comments submitted by proponents of the LGSA, that the objective is a management tool that's easier to initiate than either an INA or an AMA. The senator believes there's a flaw in that premise based on the size and scope of the government overlay that would be created. When compared to an INA, where new acres cannot be irrigated, but existing investment and livelihood of farmers is protected, the LGSA tool grants government powers that could target existing investment in irrigated lands. Compared to an AMA, where groundwater users have a direct voice in the Groundwater User Advisory Council, and most importantly, have grandfathered irrigation rights, this tool provides neither of those protections, yet has tremendous authority based on the vagueness of its power. In both instances, government grows at the detriment of citizens' rights to earn a living, yet our pursuit seems to be something that is easier to establish. Perhaps our challenge is the sequencing of this discussion, because the senator believes that the degree of burden to establish a new government entity should correlate with the powers that government will have and people will not. In the last meeting, we were charged with bringing feedback from community members that would be regulated under this proposal. The senator has done that, and based on that feedback, believes protecting existing well owners is a necessary prerequisite and perhaps a common objective in this discussion. But she's firm in her belief that bigger government with diminished rights compared to existing tools, with the goal of easier creation than those tools, do not go hand in hand and are difficult to reconcile.
My initial response is, I think many of the statements you made regarding options to an AMA or an INA, certificated, et cetera, we just haven't addressed yet. Many of those areas I think you probably have agreement on. And I think we're kind of getting ahead of ourselves when it comes to some of these broader issues that we have not yet discussed. And so what I would ask is that, you know, we give this process a chance, go through and discuss many of these issues and many of these items, because I think many of them will support some of the items that the senator has outlined to us in her rural groundwater management principles.
Thank you, Bruce. If I could just respond, if we could go back to the slide where we have the key components.
And may I ask that people identify themselves when they're speaking?
Yeah, this is Grant again.
And this is Bruce.
Yeah, okay, Grant, I didn't recognize that that was your same voice. Sorry about that.
It's all right. So what I don't see on this key components is expanded, and I believe under this proposal it would be expanded DWR powers under this proposal, because there are things, and I'm referring specifically to, you know, slide 43 of the last proposed edits by DWR that allow prohibition of groundwater use, required metering, mandatory conservation programs. And that discussion will lend to the burden that is required to initiate. If the government entity has the ability to take away existing investment or you know, a farmer's right to earn a living, then it by necessity has to have a different burden to initiate. If the goal of the tool is to provide funding or voluntary programs, then the initiation requirement can be different, because it had the government entity has less powers.
So Grant, a few comments. So on the prohibition of groundwater use, under the current AMA structure, for example, if agriculture goes out of production, new agriculture can't be put into production, right? So in terms of expanding what's already existing, that's just one example of something that could be construed as already prohibiting the use of groundwater, right? In terms of some of the other issues, if you could go through that, because I don't have that slide in front of me, some of the other points, because I had some other comments.
So the powers granted to DWR include requiring groundwater measuring and reporting for non-exempt wells, the adoption of rules governing the location of new and replacement wells, the implementation of mandatory water conservation programs, and the prohibition or limitation of expansion of groundwater use. And I understand we're comparing it to an AMA, but the difference, there's two main differences that I see. One, in an AMA, you have grandfathered irrigation rights. I know we're going to talk about that too. But when AMAs were created, it was the understanding of CAP supplies and renewable resources were coming, and we don't have that same situation today. So they can't be compared hand in hand, but yet we're trying to create a tool that is easier to initiate than an AMA.
So we can talk about whether it's easier or not. I think there are maybe more pathways than the pathways to create an AMA. Whether they're easier or not, I don't know. That may be in the eye of the beholder. And certainly, I agree with you that one of the points of discussion when the groundwater code was passed is we knew CAP waters coming to those active management areas. Although, as it turned out, no CAP water ended up in Prescott. And as we see today, the CAP water to the farmers in the CAP service area is gone and may come back someday or may never be back, depending on how things work out with the river in the future. So those are all, good points for discussion. I think, again, comparing it to the AMA is an important piece of this discussion, again, because the director has the power now to create AMAs in every single basin in the state that's not an AMA if they meet the criteria. So I think comparing it to what could happen in an AMA or an INA now is a very legitimate discussion to be had. And you raised some of those points.
Yeah, and on a related note, we, upon further analysis at the department, we have some legal concerns. If we could go back to the criteria. Specifically, we have questions about whether these criteria are easier than an AMA or if they're meant to be similar to the AMA establishment criteria. And to the extent that they're different, we need more understanding of what the differences are legally. So I think that's an important discussion for the committee to have, like, regarding these criteria.
And if I could just respond, and I think that's a worthwhile analysis, but it's an underlying premise that has been driving this proposal. It's been said in this committee that we cannot have something that is more difficult to create than an AMA or an INA. And in the most recent set of comments, the premise was we need something easier to create than an AMA or an INA. And if that premise is driving the criteria, it cannot be separated from the expanded powers that the department would have under that it does not currently have.
So I think there's a difference between not being harder to establish and being easier to establish. I think that not being harder to establish could mean that it's equivalent in terms of the process. I think that easier to establish is different than that. So, but again, I think we need more discussion of the criteria themselves and what is really intended and whether they are supposed to be broader or easier. My concern is there are a lot of circumstances, factual circumstances that could arise that might satisfy one or more of these criteria, but would also satisfy one or more of the AMA criteria, and that we might be inadvertently making it harder to establish an AMA than we're intending, because it does seem like the criteria are different and there should be a circumstance where you can establish one and not the other. I don't think it's really clear to me, at least, what we're intending, how we're intending to distinguish between those two. And it might be that what is really desired is a path for establishing a framework for groundwater management, perhaps even under the same criteria as for an AMA, but that allows for local control of the management components as opposed to ADWR-driven control. And if that's what we're really looking for, then maybe it makes more sense to have the same criteria that we have for establishment of an AMA, and then an additional component that calls for an interest in local control.
And Grant, I think some of the questions you were asking will be addressed when we talk about the plan in an area plan. One of the primary objectives of this was just an option from an AMA or an INA. And as Nicole mentioned, local input because of the unique circumstances associated with all these basins. And so it's more of a collaborative partnership together with DWR and with local input to develop management schemes and management programs that work for the local areas depending on their unique circumstances.
Bruce, may I make a comment here? This is Sharon.
Yes.
Okay, thank you. I just want to underscore that I think these are very important discussions, and I want to indicate that I myself have been somewhat confused as to the sequencing of discussion, particularly as it relates to the extent to which ADWR controls this. And to Ron Doba's point earlier about resources and staffing, I have questions about these local councils, and I realize I'm out of turn, and I'm just putting this on the table as to where the staffing comes through, because this is different than the AMA in terms of how plan gets developed. And originally, as I've been watching this for many, many years, over time, a goal has been to give more local control. One size does not fit all. And sometimes that was done in a way that gave local boards and councils, whatever you might call it, significant control. This, what we're talking about here, seems to have, and it was in the earlier slide, significant control by ADWR. And I think that's something that if it needs to be clarified, that this is a proposal that ADWR will implement, oversee, whether they staff it and so forth. So I do think we have some fundamental issues, at least I will put on the record, I'm somewhat confused about.
Thank you, Sharon. Please do keep that on the record because I think we'll need to discuss that at a later date. At this point, I'd like to keep us focused on the initiation criteria and DWR's ability to initiate the process. Thank you.
Bruce, this is Abe Springer. Can you hear me?
Excuse me, Abe. Jamie had her. Oh, go ahead, Abe. Go ahead.
Yeah, thanks. I've had difficulty with the remote connection for a few meetings. I would like to discuss the strike-through language indicated here on the criteria and indicate that the information that the agency has provided related to water levels and wells is helpful, but it's incomplete and inadequate to regulate groundwater outside of the AMAs and INAs. Most people in the AMAs and INAs are used to having no groundwater connected to surface water. They have no flowing springs, they have no flowing streams, and merely they just continue mining groundwater and track those depths as they decline through time. In the rural areas, we have the benefit of our aquifers are still connected to our streams and springs. So it's critical that those streams and springs continue to support the economies, the cultures, the livelihoods of the people who depend on those groundwater dependent surface flows. So I would strongly encourage a criteria to be, in addition to water levels in wells, that the groundwater discharge to streams and to springs is another criteria that's considered in the management of groundwater in rural areas.
Thank you, Abe. Any comments?
I'd just like to have some input on part of why we removed these provisions. Part of it was in response to a comment from one of the committee members, a suggestion, but we also agreed with the suggestion because in Arizona we do have an imaginary line drawn between surface water and groundwater, for better or for worse, and it's a legal line. And it makes it very challenging to try to manage both surface water and groundwater together. I think under those circumstances, given that the directive from the governor's office is to approach groundwater management, we need to separate that out from surface water management. I think that's also important in light of the adjudication that is ongoing. I think it would be very problematic for ADWR to start dabbling in surface water management anywhere in the state. And I would note that while we did receive comments regarding the Santa Cruz AMA, that was a very unique circumstance. The AMA was established by the legislature, broken off from the Tucson AMA, and they also had in their legislative intent language the need for binational cooperation and coordination because of an international river. And I think that anything that involves such unique circumstances probably needs more specific guidance from the legislature than we should be delving into in this process. I think at this time, we have enough work to do just talking about groundwater management, and then maybe a separate process for the need for surface water management if that's appropriate.
And this, Bruce, I don't know if you, Bruce, if you can hear me again, I'd like to respond to that.
Go ahead.
And since Ron's there in person, I might let Ron follow up on this more directly. But the Coconino Plateau Water Advisory Council for more than a decade has proposed for a rule change. And I haven't gotten a straight answer yet if the rules moratorium is still in place at the state. But what some of the rural areas the state have recommended is that instead of depth of water, a percent of saturated thickness may be a more appropriate indicator and a management tool for some regions.
Ron?
Thanks, Bruce. Ron Doba. We've been working on that project now for a few years, and we're doing some groundwater modeling work. We've been successful with some grants that we've received from Reclamation. We are looking at the possibility of making a recommendation for users of the Coconino and the Redwall Muav aquifers that 1,200-foot depth to water level be changed to something that makes sense for those folks, because they have to drill deeper than that just to access the water, even though there's a lot of water available down there. So we're in phase 2 of that work right now. We anticipate having it completed the end of this year, and then we're going to be talking about what kind of outreach process we're going to go through with stakeholders to help ADWR facilitate a possible rules change. Now, I don't know where we are with the moratorium on rules changes right now. All I know is it's taken us a lot longer than we thought it would take us to go through this process because the funding that was required for all the modeling work.
You know, we'll move on, but to maybe consider also, to avoid some of the legal complexities associated with groundwater and surface water, potentially this could be an issue if you do establish one of these rural groundwater management areas where this is an issue of concern, that it could be part of the planning effort that the council suggests. That is one of the objectives, versus having it being an initiation criteria for the director.
Is it my turn?
I think Jamie, and then
Okay,
Jay,
thank
and
you.
then Stephanie, and then Chris.
Jamie Kelly, for those that are online. I don't remember exactly how Mr. Hanna stated what he understood the goal of the committee to be, but it is Mojave County's goal for this committee to recommend a tool that affords us the ability to manage the aquifer, to ensure its long-term sustainability, to protect our local economies, and to provide water certainty for our residents. Nicole raised some concerns I think would be need to be explored, but at the appropriate time. I understand some of the concerns and the criteria differences between what's in the LGSA and what's in the books otherwise. I would think ADWR would have an interest in unifying that criteria just to make it easier to administer all of the statutes. We are concerned that the existing criteria doesn't allow enough flexibility to afford a response, a timely response, when an aquifer is being threatened. The existing criteria for an INA was problematic for Mojave County. I think we were 5 or 6 years in developing the data to allow, to petition the director to provide the data to support the establishment of an INA. And in that time frame, additional wells were put into production, and the aquifer's been harmed. The local economies have been threatened, and the water certainty for the communities surrounding the Wallapai Basin or in the Wallapai Basin, and in particular, the city of Kingman has some concerns about its long-term water certainty. So, thank you.
Thank you, Jamie. Jay.
Thanks, Bruce. Jay Tomkis for Intertribal Council of Arizona. Just to go back to Nicole's point about the surface water discussion, I'd just like to point out that federal law does not recognize the legal fiction between surface water and groundwater. And so it may be appropriate in these initiation criteria to think about establishing the framework or allowing the framework to be established for cases where there may need to be mitigation related to establishment of a federal reserve water right, whether that's for a tribe or for a non-tribal federal entity. So if we're thinking about this tool as giving the non-federal water users a flexible ability to deal with the challenge to their groundwater, then that could be used in that context. You know, and maybe it would hit other initiation criteria, but the ability of a local group to be established to help deal with establishment of a Federal Reserve water right, whether through settlement or through decree, could be an important tool, not just for the tribe to have someone to negotiate with, but also for the local folks to find ways to mitigate impacts to those rights.
Thanks, Jay. Thank you. Stephanie?
So just a couple of comments, I guess, trying to keep track of everything that's that's been said. But I did want to go back to the key concepts slide. Had a comment. I first of all say that I think that for context, I don't know if some people are using the word flexible interchangeably with easy, but I feel like a lot of the conversation we've had to date, I've heard people say, well, this shouldn't be something that's more difficult to create than an AMA or an INA. It should be easier to create. And so I'm not sure, maybe they're thinking flexible in their mind and they're saying easy, but I don't think they're the same thing. So maybe if we can just keep that in mind as we're talking. And then on the surface water, I totally agree with everything that Nicole said. Not that that matters because she's an attorney and I'm not, but I understand what she's saying. And I agree to that. Including surface water in this, we would absolutely protest that all the way for all the reasons that have been said. And I don't think that local folks, Jay, to your comment, I don't, in fact, I know that any local entity would not have the capacity or the understanding of federal water rights and all that goes into settlements. That would scare me to death to put that kind of work in that area. But that being said, going back to the key components, it's difficult. I will say this, it's difficult to have very specific conversations about the key components if we don't know going into this, and I guess this is back to reference to Grant's comments, it's difficult to talk about initiation, creation, council membership, council duties, area goals. I mean, we obviously have thoughts on all of the things that have been put in front of us, but it's difficult to comment on those not knowing what the threat is to current uses will be. It would be much clearer and easier to make comments, very specific, detailed comments, if we had an understanding that we were protecting existing well users, whether that's exempt or non-exempt wells, if there was an element of protection for those existing uses. And then in the context of the data collection and the metering and all of these things, knowing that there would be an avenue to protect, to have a certificated water right for those existing uses. If you know that, your comments to these would look a lot different. So I guess I would just say that I don't, we obviously have thoughts on all of these things and the stuff we're going to talk about today, But if there's not a sense of security in that sense to protect current well users and people that have made that investment in infrastructure and put it to beneficial use for some time, it's very difficult to have the conversation.
I just wanted to ask a clarifying question. When we discuss protecting existing well users, is that intended to be in the nature of like establishing a groundwater right or clarifying that we're not going to shut down existing pumping? Or is that saying that existing users should be exempt from any sort of conservation requirements? I'd just like to clarify whether there's a distinction there.
And what I'm saying, speaking from our thoughts in the ag community, it's about a certificated water right. To say this is the water you've been putting to beneficial use, and this is the water that you have right to.
And if I could respond to that, Stephanie, I think I need to look back at previous presentations where we provided more detail, but I believe the information that we have shared does recognize existing water users. We haven't come up with a term, whether it's a certificate, acknowledgement, or whatever that might look like, but I think those are future discussions that we need to have. But nothing that we've suggested, as far as I'm aware of, suggests that we don't recognize those existing users.
And I would just add that I think there are constitutional protections that would prohibit us from actually shutting down uses. It's one thing to have conservation requirements for water use that are reasonable. It's another thing entirely to say you can no longer use your water for the purpose you've been using it for. That is definitely a vested right. And so we would recognize those limits, and I think it makes sense to recognize those statutorily for everyone's clarification and benefit. And I think the way that those rights or uses would be established to make sure that they're protected is something that can be discussed.
Jamie, and then Trent just reminding me we're way behind schedule. Oh, I'm sorry. Representative Travers.
Well, two questions. You had a comment, didn't you? And you, go ahead. My comment is I want to hear her comment. And then I have another comment, but her first.
Okay. Sandy.
Other people have made that since that time I raised my hand, but I think the key element here is the conversation will be very different with the security in the sense that there is a protection for existing water users, albeit with some responsibility for wise use of that resource, if it's through conservation or whatever. But the conversation about the makeup or whatever it is, the initiation, creation, and council membership would be a very different conversation if you have that understanding of protection. And also, I mean, I still plug, if we knew what the roles and duties and the boundaries were that we're operating in, going back to the question of, are we creating pseudo AMAs or non-AMAs or something different? So yeah, that's, I agree with Stephanie on the protection issue. There are existing water users across the state who've invested a lot in their resources and need to have some certainty. And I think it's, a recognition, a legal recognition of certainty for the process to move forward more smoothly.
Thank you. Jamie.
Jamie Kelly. I understand the vested rights argument, but I don't know that I fully understand what legal certainty well, not the legal certainty, the protecting existing uses subject to conservation. To the extent that that could include a priority system, I find that objectionable. It's not working anywhere. It's certainly not working for the state of Arizona in the Colorado River situation, and does not seem to be going so well in the adjudication process.
If it were up to me, I would suggest that we not get into priority systems and trying to adjudicate the priority of rights, please.
That would be the response I was looking for. Thank you.
My only comment was going to be just, we are spending too much time getting down into the weeds. I think the idea is to just come up with just, like when you're writing something, you just put your thoughts down on the paper and then kind of work it from there. And we haven't even gotten to that yet because we're busy taking line one out of something and crossing something out and kind of going over and over about just a concept that we haven't even fully formed yet.
So I was just going to ask, in terms of heading to a path to create a certificate or whatever you want to call it for the existing users, does it fit in any of those bullets on that screen, or is it a separate bullet all unto itself? Stephanie?
Well, in terms of the nature of discussion, I think it would have to be within the initiation and creation, because if we don't have that established, then it's difficult to talk about how something's going to be initiated if people don't have their rights secured at the time that the action has been taken to initiate it. So that's my feelings. I don't think that, I know it was said that mandatory conservation, I guess from an agriculture community, mandatory conservation can easily be seen as taking water away. I mean, that's what's happening right now in the AMAs. They're being cut by a certain percent with each management plan. Well, that's water they were using before that they're not using now. So, I mean, you can call it conservation, but you're still mandating that somebody's water is being taken from them that they were using before. I'm not saying that shouldn't be part of it, but I'm just saying that's taking somebody's water. So
Stephanie, I'll just offer that I don't know that you can have the rights established before you have an initiation and creation. You have to initiate and create, and then as part of the process, create or assess and have those water rights certificated. Unless we're looking for a statewide process that's going to create a bunch of water rights with no context. So in the AMAs, you create the AMA, and then you have the process based on the historical use of creating the water rights. And is that not workable in this situation?
Well, I think for the purposes of what we're doing today, it's not workable because we're creating the language which creates the initiation and creation. So if you want to make that certificated right available after the initiation and creation, that's okay. But for the purpose of what we're doing here, of how to do that, my comments are going to be a lot different. Like, in other words, for the initiation and creation, it could be any one of those things, including drinking water is the only available water source. Well, as has been said here before, is there anywhere in Arizona outside of an AMA where drinking water is not groundwater? I mean, that right there, just having that, only one of those has to be met. So somebody could initiate the process just based on the fact that their groundwater is their drinking water. They don't even have to have exceeding estimated recharge rate, physical indications of overput. They don't have to have any of that. All they have to have is that last line. So if we don't have the discussion now of current groundwater users being protected, then, I'm totally opposed to that last bullet because that's everywhere. And it can be based only on that bullet. It's not one or more of the first two and the three or whatever. It can be established just based on that. And so if that's what we can establish a new government entity and a new government regulatory scheme on in Arizona, and we have no certainty for the people that are going to be mostly affected by it, then I'm totally opposed to that last line. So it would be helpful, I think, for the discussions to have the discussion of what is the security going to be of those current users, what's that security going to be now, and have it included in the bullets under, I don't know if you want to go to the slide where it actually talks about initiation, but within that process.
Jamie.
Thank you, Jamie Kelly. It seems like the cart and the horse discussion. Which one are we going to put first? I think you can discuss the initiation criteria without getting to the water certainty issue, because I think underlying the water certainty issue is the vested rights argument, and I don't think that anybody's going to undertake or challenge a vested rights situation. The idea is not to adopt a statute that's going to end up in litigation the day after it's enacted. I just think you may have raised a point about the criteria to initiate, and if we define it more carefully, perhaps we can give you some more certainty along the way of what that process looks like. Because I don't think anybody in the room's objecting to water certainty. I'm going to object to a priority system. But I don't think you can stop an existing use. But if you're never created, it doesn't matter.
Grant, and then Chris, and then what I'd like to do is put some closure to this discussion a bit with a suggestion.
Thank you, Grant, State Senate. This has been a great discussion. I'll just reference Senator Kerr's comments on the proposal. In her comments and in her model, the certification of the groundwater rights would occur between initiation and creation. So at the point in which the petition is received by the director and all the criteria are satisfied, the department would certificate groundwater rights before it could exercise any regulatory authority. And we felt that discussion also bled into incentives for well metering and reporting and could be talked about together with that.
Thank you. Chris?
I need help with formation of my question, so you guys waiting on your assistance. But if I'm not mistaken, correct me if I'm wrong, but we're not excluding or irrigation grandfathered rights are off the table. At least in the Assured Water Supply Committee, aren't they looking just at type 2 grandfather rights? That was about all that farmers got in the Groundwater Management Act, as I understand, was irrigated grandfather rights. And I don't know if that would apply to rural areas in this process of coming up with whatever's agreed to.
I think what we're talking about is a recognition and a certificate that actual use exists and that there is somebody that's using water, and how we frame that, we haven't yet discussed. What I'd like to do.
Wait, Bruce.
Oh, one more, Chris, yes.
Yeah, I've been trying to jump in to comment and respond to Grant's opening comments, but now I think we're just so past that. I'll just, maybe then Nicole's second comments. So Nicole, I think you raised some good questions, and from the rural communities that put this together, one thing to keep in mind is these criteria were important to them. So that's a big reason why they're in there. And then also recognizing the existing criteria to establish a subsequent AMA, that's pretty broad. And so inherently, there's probably going to be some overlap in the criteria between a third option, a tool that's by and for rural Arizona, and the AMAs, and we'll have to work through that. And then Nicole, maybe one concept to think about, which isn't up there, but could be additional wording like, and an AMA is not needed, or something like that. Because when we talk about the 3 pathways to designate, just in this concept, like there's the County Board of Supervisors resolution, the 10% of voters. If this third tool is initiated through those pathways, presumably it would be that tool, like it wouldn't just jump to an AMA, right? So we're really talking about the director designated arena. And so maybe it does make sense to sync up the criteria. But from our view, like just Grant, in response, like to some of your comments, like I wouldn't see these criteria as necessarily harder from the AMA criteria, but we could certainly sit down and hash that out, easier. Because I think there is value in having like a comparable set of criteria, right? Because the AMA criteria is pretty broad, especially that first one, and I don't have the language in front of me, but additional management actions are needed, things like that. And even the INA criteria too, depending on how you look at those. And then The, just specifically on the drinking water, that's a criteria that's been in the proposals from rural communities for years. That has been deemed important by them. Where it came from, that's actually from the Texas Groundwater Conservation District model, blended with some of the existing active management area language. So the additional action and cooperation, et cetera. So that's where it came from, if that's helpful context. And I probably had other comments that I missed, but I'll stop there. Let you move on, Bruce.
Thanks, Chris.
It is germane to this.
Stephanie, yes.
Oh, yeah, I forgot. Yeah, I know, I'm catching up. So on the need for protection, certificates, shares, I think we can certainly have that conversation. I think that relates to whether this is a temporary structure or not, because as we all know, groundwater rights in Arizona do not exist outside of a management or regulatory overlay. And so we could put that to the side, but certainly we can talk about certificates, shares, because like Jamie said, I mean, the goal is certainty here.
Thank you. Stephanie.
Another point on the bottom bullet, which I have a question about that I need clarity, is where it says meeting the water supply needs for the water users and communities within or withdrawing water from the proposed area. What is meant by communities withdrawing water from the proposed area that are not within the area?
Chris.
It's supposed to be from within, water users within. The intention there is to be communities within the area, right? Because it wouldn't be, yeah, there wouldn't be any transportation happening because that's not allowed through this proposal or anywhere else. But another concept to think about would be, so the AMAs have a criteria related to water quality, so that could potentially meet that intention, or it could be a water access related criteria, so just a couple other concepts.
You know, what I'd like to group so that we can get away from delving into the details at this point is if we could step back and if we could get some level of concurrence on higher level concepts. One is director has the option to initiate the process. Can we get some agreement on that? Can we get agreement?
So, I have to comment on that. Thank you. Grant with the Senate. The senator has concerns. I think that and the director can comment to this, but the delay in implementing INAs and AMAs has been the actual local support on the ground. And so under Senator Kerr's proposal, you would have the consent of the governed before the director just initiates this proposal. I think what we're doing here is taking an area, we've identified an area like Wilcox and where I think the proposal to create an AMA was defeated 2-1, and we're saying here in Phoenix that, we kind of know better than you guys, and we're going to be able to have the ability to initiate it. The senator's position is that a local election is absolutely necessary and buy-in from groundwater users. So I'll refer again to her proposal. We've submitted again with our comments. It's contained within.
Thank you, Grant.
I would just like to push back on that. So far, we haven't had any. We have allowed consent of the governed, in theory, and we're at where we're at now. So I think it's important to have very much local input. But if we allow it to continue in this framework, we will end up where we already are now, if not worse. And I think that's the reason for having some of the ADWR input, is because, it's at some point somebody has to come in and be the adult in the room. And I know that's a poor metaphor, but it just, yeah, I'm not so sure. That's my concern.
Chris.
Some comments I've recently received, Chris Udall, by the way, some comments I've received recently is kind of along lines of what's been said. We have there's some that don't believe that everyone is represented around this table, and that there probably would hopefully be an opportunity for more stakeholders to provide input, however that is, wherever that methodology is.
And I would ask that, they can contact the department and they can contact each of you for more input. Yes. Jamie.
Thank you, Jamie Kelly. We clearly support DWR having the director having the ability to establish the district. We believe, or the groundwater management. We believe it's consistent with the duties that he's charged with in the revised statutes that establishes the position.
Thank you. Chris.
Yeah, I agree with Jamie. Just back to why we're here, create that third option for rural Arizona. And so given the director has the authorities to unilaterally designate AMAs and INAs, it would make a lot of sense to also give the director the authority to do that third option. Otherwise, we're still left with AMAs and INAs in that arena.
Ron.
Ron Dilba. One of the concerns that we have is the people that are making the recommendations and the decisions in this process are water literate, so to speak. And I can't think of a better agency in our state than the Department of Water Resources and our director to be at the end of some of these final decisions.
Stephanie.
So I think since the other two options, or the director already has the ability to make that decision outside of local input, and this is supposed to be an option that is supposed to be more locally led, then if the director is involved, it needs to be as a secondary, somehow emergency type deal. The local part of this has to be at the forefront. And the reason that the local people have not chosen areas like this in Wilcox is because they didn't like the options that were presented. They didn't want an AMA because they don't have CAP. They don't have, it's regulatory in a way that they don't have options. So it's not that people aren't capable of controlling their own destiny and making good decisions. It's that they have to have options that work for where they are, which is why this is so difficult to come up even with a third option that people think can be applied to the rest of the state. I have confidence in local people to care about their own resources and to manage them well, but they have to have the way to do that. And so I think the reason it hasn't been done is because that way is not there. Going back to Chris's comment, the reason why we're here, but the director option, at best should be secondary.
Sandy.
I still think that you need the backstop of the director, because even at the local level, there's not 100% consensus, and there needs to be some boundaries. And rather than creating, rather than handing over a blank check that anything goes, there needs to be some boundaries on that, and that's the director's role. He or she will be that possible tool, not that you're a tool, Tom, but essentially could provide that those boundaries that come from the legislature and the executive as well, because I don't want to create something that is not achievable at the end of the day. We want to create something that's actually achievable.
Thank you.
I have a quick
Yes,
comment,
Representative Tran.
just so that I can understand it, because I'm not as well versed as everybody else here. It just seems to me like what we're trying to create is like when you go to a gym and you get different memberships, right? You can get like your copper membership, and then your silver membership, and then your platinum membership. And it feels like the rural management that we're trying to create now is kind of something like your silver membership, right? So it's not the INA, which is like a copper, but it's not the platinum standard of the AMA. And so, and yet within that silver membership, you also have like a telephone company or one of the insurance companies where you can kind of choose your own segments in each plan, right? And that's what makes it so flexible. It's not fixed, and that's why we're trying to create this framework. And when we say local control, that means that not everything is going to be the same in every basin that we look at. You're going to be able to kind of pick and choose with guidance the things that are going to address your situations best. Is that my understanding correctly?
Yeah, I don't think we're proposing a gold, silver, or bronze type membership, but what we're proposing is that the essentially the locals will set a goal, and then they'll sit down and develop a plan.
But the LGSA has parts of the AMA.
It could have parts of the AMA, it could have parts, we're not refuting any of those options if that's what the locals would like to do, whether it's AMA light, AMA strong, INA light, INA strong.
But it's when you look at the membership grids, and each thing checks off different things. And the more that you get into your higher memberships, it checks off more boxes of things that it does.
Right.
See, I do think it was an appropriate matter.
Okay. Thank you. Chris.
Just support for ADWR on the designation, working with the locals. You all were created by the 1980 Groundwater Management Act. This is a well resource, and I think that's, for me, it's a given. It's kind of a no-brainer.
Thank you. So we don't have full support, full consensus, but it seems as if definitely majority consensus. Director has the option to initiate the process. Another item, criteria is not more onerous than an AMA, and that it should at least should be created when the aquifer is overpumped and water supplies are being threatened, in general terms. Do we all agree with that? Ron
Doba, just a comment on that second bullet as far as the indications of overpumping. I don't know if we need to kind of zoom in on those indications so that we don't, we all know in a basin there's going to be some wells where when you track the groundwater declines, we're going to be seeing the declines. Other wells, we're not going to be seeing that. I don't know if this could be refined better, possibly, so that we don't see somebody trying to initiate one of these based on a half a dozen specific wells in a certain area it's not really representative of the whole basin.
Thank you. Agreed. Sandy.
Thank you. I'm just curious, Ron, I mean, at least at a high level, are the criteria sufficient? What was laid out, is that sufficient? And the details of that should be worked out a little later.
I agree. I think at a high level, we're good. I also had a comment about the first bullet point, the estimated recharge rate. Are we, depending on how deep we want to get into that, are we talking about natural and artificial recharge? Who's doing the estimation? That sort of thing.
Okay, let's move on to the next slide. Local initiation process. So not only was it the DWR initiation criteria, but there's also the option for local initiation. A petition to consider designation of a rural groundwater management area may be submitted to the director if either a resolution is passed by the County Board of Supervisors of all counties with lands that are within the boundaries of the proposed area specified in the petition, determining that the public interest, convenience, and necessity will be served by designated or rural groundwater management area, and it is signed by 10%, or it is signed by 10% of the registered voters within the boundaries of the proposed area specified in the petition. We had some comments on this. Chris and Haley, why require all counties? Are there basins within several counties? I believe there are. Senator Kerr, petition should be signed by a majority of groundwater users and or voters. And Jamie Kelly, she agrees with the proposed process. Comments? Sandy.
Thank you. The criteria for 10%, I struggle with that, particularly when you have multiple counties and how that becomes doable, because it could be 10%, it could all come from one county. And I do tend to agree that it should be more than 10%. It just seems like that's an awful low number.
Okay. Okay. Thank you. Chris?
Chris Udall. I don't know, I would agree with that 10% issue. I don't know if this fits for every county. I think of my hometown, my home county of Apache. Most of those discussions I've had, it's mostly decisions are going to be federal related. And so I don't know how you make this work if you, I don't know if you can include all 15 counties, I guess is what I'm saying.
The Board of Supervisors and the counties would be based off of the size of the basin or the subbasin. So if the subbasin's in 4 different counties, do you have then all the counties? That's the issue. Representative Travers.
As one of the few people who have actually had to go around and collect signatures, it is really harder than it looks.
Yeah, if you have a suggestion on the percentage, I'd be interested in what that looks like. Yeah. Ron, please.
Ron Doba. We have some conditions that are identified, or metrics, if you want to call them that, for the director to take into account in making a determination of one of these. Do we need to also identify those for a county to take into account before they adopt a resolution? They need to adopt a resolution based on the same criteria, don't they?
Chris?
Not sure I totally followed the question, but
The same criteria that the director had, the 3 items associated with creating.
Oh, right, yeah, so same.
Same.
In the proposal, in the proposal we worked on last year, it would be the same criteria regardless of the pathways, 3 different pathways.
Right.
Yeah, and then on the 10% number, just again, I keep saying this, but that's the standard to petition for a new INA, so that's where the 10% came from.
Stephanie? Stephanie?
I would just agree that 10% is way too low, especially if we're talking in terms of subbasins. I mean, there's some subbasins in this state where there's not very many people living, and that would mean a handful of people could decide something for everyone else.
Okay. Thank you. Karen?
Just a question about that last option. As I'm reading this, it's either a county board of supervisors resolution or a petition with some number of registered voters. But does that petition have to follow the same criteria? And how would they determine that?
So,
Nicole?
yeah, I think that the criteria are essentially the petition only needs to request that the director consider designation. And then the director would make the final determination of whether the criteria are met. And whether one or more criteria are met. I think that's the intent. And then I know there were questions about the county overlap with the basins, and we did see that issue in the Wilcox election in particular. The Wilcox Basin has portions in Cochise and Graham counties, and so they worked with us to identify the area, in particular in Graham County, to identify the portion of their county and find the registered voters within the basin boundaries that were also within their county. So that was what happened. And I know there was also a question about a majority of groundwater users, and I know that's in the AMA legislation as well. But the problem is that in a location where you don't have any sort of reporting or rights, you don't know who the groundwater users are, so you can never determine a majority of users if you don't know who they are. All you can have is a majority of the users that tell you they're users. And also it's not clear whether that would be individual people as users, is that individual voters as users, is that based on well ownership or well operators. Groundwater users is not really well defined, even if you knew who owned all of the wells. Some users may own dozens of wells, and others may just have one to support their use within their home for the exempt well owners. So,
Stephanie?
So I guess I don't understand why it would be so difficult to consider that in terms of a majority of groundwater users being those with registered wells, because they're the ones that are going to be regulated. So if it's the majority of groundwater users, which i.e. would be registered wells, I guess I don't totally understand why that would be a bit difficult.
yeah, so then would it be a majority of well owners? And is it one vote per owner or one vote per well?
Jamie?
Thank you, Jamie Kelly. I have some concerns about it being on dictated by registered wells, because not all registered wells are used. They're registered, but that doesn't mean they're using. So how do you define that? I just wanted to echo Chris's comment about the 10%. I think it's important to have some uniformity across the water statutes, that it be consistent, that if it's 10% for INA, it should be 10% for this. I agree with Representative Travers. If you have not ever run for an elected office, you do not know how difficult it is to get 10% of the registered voters out there. It's not an easy process. And I think in all of this, we need to keep in mind that we're just requesting the director to establish. We're not vesting the authority to establish the groundwater management area in the Board of Supervisors, in the voters, but we're asking the director to look at it, and we need to, as Ron said, trust the water literate. Thank you.
Thank you. Grant?
Thanks, Bruce. Grant with the Senate. So this discussion's been helpful. I think for the senator, the petition process, the challenge with the petition process is that it does not carry legal weight in the director's decision whether or not to initiate it. We discussed that in 2 meetings ago, I believe, that even if a county board of supervisors submitted a petition that they did not want this, that the director could enable it. I think to Jamie's point, when we're looking for consistency with statute, Senator Griffin at the passed legislation where the county board of supervisors could put a new requirement on water users, the adequate water supply, and that precedent is a unanimous vote by the county board of supervisors. So it is, I know we're comparing it to an INA, but we've I think made the argument that we're talking about a different animal. I mean, to Representative Travers' fantastic analogy, without knowing the powers, the fear from groundwater users is what comes with the silver membership is that they can require you to lose 10 pounds or take it from you. So we don't know what those powers are, and I think that's why it's a challenge to know what the standard should be for initiation.
Thank you.
I am not joining that gym.
Yeah.
Stephanie?
So just a quick point. This last few comments have come to my point of this shouldn't be an easy process. So if it's hard to get signatures, it should be hard to get signatures. I mean, we're talking about changing the water management of an entire area, a drastic change if this happens. So again, going back to that original comment that, that Grant made, it's like we shouldn't be coming to consensus or disagreeing or whatever based on how easy or hard something is. It should be about what's appropriate given what the final result is going to be or what we're trying to accomplish here. So 10% is way too low.
So stepping back, ask the committee if we can come to a level of agreement at a higher level with the concept of the process can be initiated by a county board of supervisors resolution or petitioned by, maybe we'll leave it blank percent of very registered voters. Do you agree with that? Can we grab consensus on that? Okay.
Is there a way to have somebody kind of take a look at basin populations so that we know what 10% is? Because 10% could be 30 people, it could be 300,000 people. I mean, I know it's not going to be like that in the rural areas, but at least it gives us some kind of a benchline of what we're dealing with.
I don't know if we can do basin, but county populations, maybe, I don't know. Basins.
Where's Ryan? Ryan, where's Ryan when we need him?
Yeah, I don't think we don't have population numbers by basin. When, like I said, we had to collaborate with the counties in order to help them determine registered voters within the basin lines, because we don't track population.
Well, even that number I think could be helpful if you have.
Just for Wilcox and, for Wilcox and for the Douglas Basin.
But at least it gives us some kind of benchmark of what we're dealing with. I mean, they're not going to fluctuate from one to another that much, I don't think.
Okay, thank you. Yes, Jay.
You could probably get that with census tracts, a rough overlay of basins with census tracts. That information's out there. Well, I don't think for the purposes of our discussion, we need exact numbers, right?
Right.
Just sort of ballpark.
Yeah, we'll give general. Okay, thank you. Next slide. This is a new slide. And, well, if we could go back, I think the conclusion here is that that there is consensus that the process can be initiated by County Board of Supervisor resolutions or petitioned by, we haven't came up with a percent yet, but blank percent of area registered voters, correct? Consensus? Thank you. Yes, Ron.
Ron Doba. I think we're good with that as long as the final decision is still up to the director. It's a recommendation. I think, counties can pass resolutions on anything they want right now and send them to anybody they want right now.
Right.
But if the final decision is left up to the director, we should be okay.
Thank you for that clarification. Next slide. If the director finds that the proposed rural groundwater management area may meet the criteria or a petition is filed, the director shall hold a public hearing to consider whether to issue an order declaring the area a rural groundwater management area, the boundaries of the proposed area, which shall be coterminous with the boundaries of the groundwater basin or subbasin, except in the regional aquifer systems of northern Arizona, where the boundaries may be smaller than a subbasin if based on reasonable hydrologic or water management considerations. Any person may appear at the hearing, either in person or by representative, and submit oral or documentary evidence for or against the proposed action. In making the determination, the director shall give full consideration to public comment and to recommendations, and then within 30 days after the hearing, the director shall make and file written findings. On the process, there were some committee comments. Senator Kerr, petition process carries no weight in decision-making process. Hearing process should be followed by election in the area, and certificates must be provided for existing groundwater users, and we've talked about that. Sandy.
So the red addition, the may meet the criteria, is that just a recognition of lack of data? Or, I mean, I guess I don't understand. Why is it may meet the criteria as opposed to meeting the criteria?
Sorry, could you repeat that?
Why is may added in as opposed to meeting criteria versus may meet the criteria?
So I think that there is always the opportunity for information to be submitted at the hearing that could change the outcome of those findings. And so we would rather not have that be a final determination before we even have the public hearing. We'd rather have the opportunity for people to submit information and data that the department doesn't already have.
Sandy.
May I have a follow-up question? But to make the final determination, you have to meet the criteria. That's where I'm trying to draw the distinction.
Yes.
Okay, thank you.
Yes. Jay.
Just one, I don't know if this is the appropriate slide for or not, but in addition to the public meeting, I think there should also be a requirement for sovereign to sovereign consultation if the area includes tribal land. And so that should be separate from the public meeting process, but it should be required for the department to do that.
Thank you, Jay. Thanks. Any other comments? Jamie?
I'm not sure where we left Senator Kerr's recommendation for an election, but we would oppose that. We would defer to the director because the decision needs to be data-driven.
I think it was a minority opinion, but we reached consensus on the process on those other two slides.
Bruce, I don't believe I'm stating Senator Kerr's opposition. Yeah.
Yes.
So I don't know if we have consensus. You have a majority, but.
Majority, thank
yes.
you. Okay, thank you.
Just a quick question, maybe for Grant. Maybe just if you could articulate again, like where exactly the proposal from Kerr, Senator Kerr, to fit in an election here, and then why, and how that would actually match with, like with the thing that's established, given, at least in the current proposal, we're talking about existing authorities that the department already has, or existing authorities local jurisdictions have that would be represented in a management plan, and then the local council only makes recommendations. So help me understand that.
So again, going to the sequencing, I think we are operating under the assumption that the director powers stand as they are now. We believe they're vague and they are more expansive than an AMA. They don't carry the same legal certainty for groundwater users. It's her belief, I think Stephanie alluded to this, that the Wilcox Basin, the AMA in Wilcox, failed because it wasn't the right tool. If there is, the right tool, operating with the consent of the governor is critical, especially if there's going to be an anti-competitive ability for the government to reduce water use. So it's her position that groundwater users should be involved in the petition process, and the local community should lend their support before these regulatory requirements are initiated.
Okay, thank you. So it sounds like then there would be an opportunity to clarify powers and authorities, align those with the program, and then revisit the election question then.
Yeah.
Yes.
Bruce, may I make a comment? This is Sharon. The recent,
Go ahead, Sharon.
Yeah, the recent votes that occurred because there was a provision allowing a vote, right? I'm talking about Wilcox and Douglas, INA and Wilcox and AMA, or AMA in both cases. The director can establish an AMA with current authorities. It does not require a vote. And this would seem to, this requirement of a public vote to form a rural groundwater management authority or area would go beyond the requirements for forming an AMA and INA. It seems to have lack of correspondence here. So I don't know, maybe you want to leave that as an option to have a vote like you have in an INA and AMA, but to have a firm requirement for a vote when you don't have that for an AMA or INA doesn't seem to be kind of corresponding.
Grant, thank you, Sharon.
Thank you, Sharon. And I think at the outset we talked about how there are protections in an INA and an AMA that do not exist in this proposal, specifically with an AMA grandfathered water rights, and with an INA, the ability that your existing investment is protected. With the powers as they stand right now, the director's, the ability of the government agency to issue anti-competitive measures is larger. And so I don't believe it's fair to compare an AMA and an INA with this process based on the current powers that are outlined in the most recent proposal.
And Grant,
So-
if I may, Bruce, just respond.
Go
I
ahead, Sharon.
I put in my written comments a second short comment, and I said that it's probably not for today, and that is the criteria that the director uses to approve a plan. So I think we have a lot of balls up in the air right now about concerns and authorities and provisions, and it is unclear to me kind of what can go into a plan at this time. So I will cede that point, but I will not, I do not personally agree to having a vote to form it. And I'll say more about the other comment in your, in Senator Kerr's remarks about electing members of a council. I just want to note, I have a lot of experience with this. I was executive director to the Santa Cruz Valley Water District, and we did form an elected board because we had taxing authority. So just a little preview there.
Thank you, Sharon.
Grant, and I know you won't be able to answer this question, but it would be interesting to me to hear from Senator Kerr's view if we did create authorities for the water rights for the current users, if that would remove her concern and her need to have an election.
And I will just respond. Thank you for that qualifier. I'm here in capacity today as her staff, conveying her positions on these issues. The senator is the decision maker, and I will absolutely relay that to her. Thank you, Director.
Penny?
So if an election is not part of this process and a very small number of people can do the petition and the director can ultimately make the decision regardless of either of those things, how is this local?
Jamie?
Jamie Kelly, it would become local through the council membership and the adoption of the plan and ultimate implementation of the plan, which is going to be primarily vested with your local elected officials through their general plans or comprehensive plans.
Stephanie?
But again, jumping ahead when we're not supposed to, that council to this point can make recommendations, but again, the director ultimately decides how those recommendations are going to be implemented or if the plan will even be accepted. So that's not very strong local control either. And another question I have that's separate but based on a previous question. So if ultimately an area is established, would tribal lands be required to follow the same requirements as this area? I think I know the answer to that. I think the answer is obvious, but I guess I'm responding to Jay's question about this initial process of creation.
We have not implemented state regulations on tribal lands. I don't think you can do that. Certainly tribes can participate in state programs. We do have tribes that have recharge facilities and permits, and so they're voluntarily participating in state programs, but we don't get water reporting for groundwater use or anything.
Jay?
So just to I guess respond, it's not a question of whether the tribe is going to be subject to the rules of the state. It's that the state will be making decisions based on a shared resource, which is groundwater within the basin. So consultation isn't a veto or anything like that. It's an opportunity to be heard in the decision-making process.
And I would just add that could also be an opportunity for information sharing, because as I mentioned, we don't get water use reporting for tribal lands, but the tribe may be able to share information with the state that could be informative in the decision-making process.
Yes, sir. I can't see. Robert?
Okay, thank
Chairman,
you.
Chairman Miguel.
Robert Miguel, Chairman of the Auction Community. Again, it's obviously an opportunity to, again, get familiar. Certainly appreciate having tribes at the table now. But I was at a presentation yesterday at the University of Arizona. They talked about wells, especially on the Navajo Nation. So one of my questions, and again, I just wanted confirmed or reiterated if it's accurate, but when it comes to programs and whether it's reestablishing the wells or funding, does that, not abiding by certain regulations and rules that was from the state, does that hinder or, again, leave tribes out that do have wells for funding and whatnot? Again, just clarity on that. If we're not playing by or going by the rules in a sense, are we, again?
So I guess, Chairman Miguel, I'm not familiar with programs that would be exclusionary towards tribes. The WIFA legislation, for example, and the funding there is available to tribes as an example of, to answer your question.
Again, thank you.
Thank you. So on this slide, that higher level concept, can we agree that ADBR can conduct the hearing process similar to AMAs and INAs, and that their director has final designation authority? Looks like I see consensus, so we'll move on to the next slide. Thank you. This was an item I think that we had mentioned before, this interim pause concept. And really, the whole thought here is to avoid proliferation of new wells and pumping after a designation. Establish an interim pause within the area boundaries. In other words, the rural groundwater management area has been proposed. They're going through the initiation of the hearing, et cetera, and maybe even the process of developing a plan. The thought here is that others don't come in and start drilling a bunch of wells and start, positioning themselves. So the thought is the pause begins when the rural groundwater management area is designated and continues until the management plan is approved by the department. And the thought is, and this is where we're going to ask for your discussion, well, of course, on all these components, but no new non-exempt wells within area boundaries. The exemption is for supplies necessary for protection of human health and safety, and the exemption is for replacement wells unable to drill in the same area. Sandy.
Thank you. So the same timelines would apply, though. I mean, we wouldn't want an unreasonable amount of time to go by where you have that pause. So
yes.
when you're establishing AMAs, you have so many days.
Yeah.
And
Yes.
Yeah. As
That's
long
good.
as that is.
Good.
Yeah.
Yes. We would need to come up with the reasonable timeline. Yes. Jamie.
Thank you, Jamie Kelly. I would just request clarification that the protection of human health and safety and/or the replacement wells takes into consideration requirements on municipal water providers, particularly those regulated by the ACC. I mean, cities would need the ability, if their well went down, to replace it, or if they were right on the verge of needing to put in a new well to service their existing residents, that they would have that continued ability.
Yeah, I think that was the intent of having that exception included, recognizing that people need water.
Thank you.
Thirsty.
Stephanie.
So first a clarifying question and then a comment. Is a municipal well considered non-exempt or exempt? I'm not talking about a domestic, I'm just talking about like a municipal water provider well.
It's the size of the well. Non-exempt is the size of the well.
So that would be a non-exempt well?
If it's greater than, yes, if it's greater
Okay.
than 35 gallons per minute.
Okay.
The slide should probably say exception rather than exemption.
Okay. So then I would argue that if there is a pause on wells, it should apply to everyone. Because then you end up with people coming in and drilling wells and then complaining that they don't have any water. I mean, that's part of the problem now, is that people should have been told, your water is at risk when they were drilling in places where there was a lot of water use. So I don't understand why, if there has to be a pause and there has to be an emergency and to figure this out, there should be a pause on all wells,
Exempt and non-exempt wells.
exempt and non-exempt.
Okay, thank you. Any other thoughts? Ron?
I just want to make sure I understand what Stephanie's saying. I think she's saying that maybe the exemptions should be removed completely during that period of time for all wells, right?
I think that I think I'm saying
new
that there
wells.
should be a pause on all new wells.
Yep.
It doesn't matter what the well is for. If there's going to be a pause, it should be on all new wells so that you don't have people continuing to drill wells when there's not enough water.
Jamie?
Respectfully, I have to disagree with that. I think municipalities and the public utilities need the ability to drill wells to deliver water to residents. And if you eliminate the exemption or the exception, you can't do that. And then you come into the powers of the regulated utilities, and how are you impacting them? I just think it's problematic to exclude the public utility and the municipal wells.
Thank you. Karen?
Thank you. So a public water system that is serving water that does not meet Safe Drinking Water Act requirements can be required to drill a new well in a place where the groundwater does not exceed those standards. I mean, we have to have the ability to tell the water provider that they must replace the well to protect human health.
Stephanie?
And I get that, and so that should be a bullet there that says unless you're being required to drill a new well. To me, that would fall under exemption for replacement wells unable to drill in the same area. You could have exemption for utilities, which are required to drill a new well for whatever purpose. But I think right now that's way too broad. If you're going to put a pause and declare an emergency, it needs to be equitable. And so I think it's definitely, you could provide for those exceptions based on regulatory requirements. But the way this is, I think this is perpetuating the problem instead of trying to help, considering the problem areas that we're looking at.
If we would like to put some more detailed
Thank you.
language
Yes.
there,
I think that if
and
we
you can offer that.
flesh this out to be very clear that when people are being exposed to unhealthy levels of some contaminant that's in the groundwater, there needs to be an ability to drill a new well.
Sandy?
Yeah, and I think the details of the exemption can be further hashed out, because there's other impacts on where you would need to replace a well that could impact human health and safety. Power is an example, so I think that's a conversation we need to have in detail and try to line out those exemptions.
Thank you. Yes, Ron?
Rondo, I just want to point out, some of these municipal water wells are like 2 years in the making. There's, and a lot of money going into them, especially up in northern Arizona. And for somebody to get so vested in this project of drilling, of locating the right site and, getting the contractors and the design and everything else, and then all of a sudden, the rug pulled out from under them at the end to prevent them from drilling the well could be an issue, so.
Stephanie?
I would just like to second that on the point of agriculture.
It sounds like we needed, I'm sorry, excuse me, Grant?
That was my comment, that there's, existing investment that we consider a 9A, and we have to be careful when we're elevating one beneficial use over another.
So what I would ask all the committee members, we need to tighten this up a bit. If you could give us your comments, and we'll come up with some additional language associated with this interim pause. Okay?
It sounds like the concept of the interim pause has pretty good support, right?
Yeah, but not at the health
the
and
level.
safety and risk of human beings.
Right. We can start. We have an option here. We can move on to next steps, or we can start talking about council membership, but we only have 10 minutes. So I think we should go to next steps. Thank you. That was Trent's suggestion too. Upcoming meetings and next steps. We have about 5 weeks between now and the next meeting. We will be coming out with a proposal associated with the metering and monitoring and measuring for all of you to review. We will come back with the results of our meeting today and notes associated with that. Tom, go ahead, Director Poshansky.
So Bruce, we had a lot of really good conversations here, a lot of good suggestions to discuss further. We didn't get to the council membership discussion. I think we need a meeting before October 19th.
Everyone agree? Do we agree with that? Okay. Yes, Sandy.
I agree that we need another meeting. I'm going to just make a recommendation, take it for what you will, but that the council membership discussion be resequenced in this post, duties and roles and duties.
Okay. So from a sequencing standpoint, what would you like to see us discuss next? If we could go back to that slide. Oop. 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 Yep.
Council duties and area goals.
Council duties and area goals next. Okay. Good. Yes, Stephanie.
So as to our previous conversation, at what point will we be, Grant suggested that the certification and security of water rights be discussed under creation. So
Stephanie, the next meeting.
Before
the next meeting, and if you want to do it, if we need to do it before duties and goals, we can do that. So I want to go back and talk with staff about that concept, consult with the governor's office in terms of that issue. I understand how big an issue it is, and I think I've heard here today that if we can figure out a way to deal with that issue, that some other pieces may fall into place. That's what I've heard. So we need to have that discussion, and we need to come back with something, and I think it should be the first item on the next agenda. Granted.
That was going to be my recommendation. Grant, again, with the Senate, is that we would talk about certificated groundwater rights along with the powers and duties. I think here we're calling them council duties and goals, but those would be this topic of the next meeting.
Thank you. So we will reach out to all of you with a couple of dates for a meeting between now and, what was the other date, October 19th, for an interim meeting where we will discuss those items, those priority items. I would ask all of you to do part of your homework is to look at the council duties and the, what was the other one? And the area goals. And we'll send that out to all of you just as a reminder, so that'll be part of your homework. And also any thoughts you have regarding the issue of certificates and acknowledgement of existing uses. Okay, any other comments? Sandy?
I was just going to add, this will be online so we can look at that language for the pause, the exception language. Okay.
Yes, yes. Before we conclude today's meeting, any other thoughts or comments or any closing remarks from the director? If not, we'll go ahead and conclude today's meeting, and thank you everyone for the very, very good discussion. Thank you.